Hey, everybody, and welcome back to the Legal Weekly Wine, where we discuss the week's hottest legal topics. We are still on fire. Today, we are going to review the decision that just came down that we've been waiting on for so long of Trump versus United States and whether he has any, and if so, how much, presidential immunity for actions while he was president. The court has finally put this decision down. There are other decisions that have come down on Monday, July 1st. We will be taking up those decisions, including the social media decision, which we think is fairly significant. But today on this show, we are only going to discuss presidential immunity with Trump versus United States. We have a little bit too much to say, probably, on this case. All three of us have very strong opinions on it. As usual, we're going to do our very best to keep a neutral analysis, to review the case as far as precedent, how it interprets the Constitution, who's dissented, why they've dissented, what their ultimate points are. But with everything in the U.S. right now, I'm afraid our opinions are going to leak in a little bit. So bear with us, offer your own opinion. Please be kind. Do comment, subscribe, like, but be kind. We're trying our best to be kind and not make any insults. We don't appreciate insults as far as just name calling, etc. If you have a point to make, please do make it. We do appreciate conversation, but not insults. And we're going to try to do the same here. I'm Virginia Tirani. I am the owner and attorney for Tirani Law, LLC, because you never need a lawyer till you do. I've been practicing for over 18 years, and we're based in Maryland, D.C., and Virginia. And I am joined by my colleague for Tirani Law with Chelsea Rogers. Chelsea, welcome.
Hi, glad to be here.
Okay, and Dr. Vial, he is the Dean of the Honors College of Middle Tennessee State University. He is a Constitution scholar. He is a scholar and expert in the Constitution, the amending process, constitutional law, and political science in general, including a PhD from the University of Virginia. Dr. Vial, it's really good to have you on the program, especially with your extreme background in constitutional law.
Good to be here.
All right, we have a lot to talk about, but I think one of the fun things we're going to start with is we've been reviewing all of the decisions that have come down for the 2024 term and 2023-2024 term, the decisions in 2024. And I want to put a rating system on it. Let's review the opinions. I'd like to do it based on hurricanes, right? They have categories. Category 5, category 1, is it more of a tropical storm? So let's rate this decision. Give you all a tickler for our thoughts on it as we break it down. Dr. Vial, I want to start with you first. As a hurricane, give us a number. What category is this decision?
Well, I think it's a lot like Hurricane Beryl. It's somewhere. It started out, most of us thinking it would probably be a 3, but it's closer between a 4, and it alternates between a 4 and a 5, depending on which part of the decision that you're reading.
Okay, fair enough. Chelsea, what category would you give it?
Yeah, I was going to say, if you're in the dissent, it's like a category 5 or plus. I'll agree with Dr. Vial. He's a constitutional scholar here. I concur.
I'm going to give it a 4.5. I'm fairly solid on my decision. And I will say, there, as legal scholars and scholars on the Constitution itself, this one has caused me a lot of angst. And I will admit that I woke up many times last night thinking about the decision. I've rarely made, and Chelsea knows how many notes I make. I've rarely made so many notes in my life as on this decision. So I know we each have quite a few opinions on it. Let's talk about what we're drinking. Now, I'll be honest, we are taping this Tuesday morning. We're going to get it out as soon as possible.
And I'm at work. Okay?
And you're at work. So you're drinking water. Now, I'm the boss of Tirani Law for Chelsea and I'm going to permit us to drink this morning, but I couldn't get up to wine. So I've chosen something appropriate, but I want to see what Chelsea's drinking.
I needed my caffeine this morning to get me very hyped. And you can hear my dogs running around, excuse me. But I am drinking a sparkling Celsius. We're back at it with a mango passion fruit.
Nice.
I'm going to get really amped during this conversation, so I needed the caffeine.
Yeah, I looked for some this morning. I usually have a Celsius or a Monster, and I couldn't find one. And then I was like, well, I know it's the morning, but so I've chosen a drink that I actually had in my pantry, in my cooler, that I think is extremely appropriate for my own feelings on this decision. It's called Sour Monkey.
Okay, that stuff is so good, though. I love that. Solid choice.
It's delicious. So it's not a wine; it's a sour ale, but it's Sour Monkey, sour triple. Victory brand. So that's kind of how I'm feeling, is a little bit sour. So cheers, everyone, and good luck with this discussion. All right.
I just want to say I'm so thankful I am not in constitutional law in my 1L year right now. That is what I'm currently thankful for, because, ooh.
Yeah.
There's actually been some articles about people being reluctant to teach constitutional law or not being sure how to do it, because so many of the some precedents need overturning, but there seems to be, not only you have overturning of precedents, but you have some ethical issues on the court that haven't been certainly highlighted as much, lately.
Yeah.
And one of the things about today's decision, there's some, the way Roberts words it is somewhat enticing, which is, and particularly for those of us who are concerned about a future Trump Trump presidency, he's already threatening to use the Justice Department against others, including Biden. And so, it's sort of enticing to say, let's not get too caught up in this particular set of facts. Let's think for the future. But by doing that, he's ignoring the fact that 6 months ago, the court could have said, let's go ahead with, we had very reasoned decisions, I thought, from both lower courts. These are within the bounds of acceptability. Let's go ahead with them. If they make a mistake, we can always come back and do a correction. And, the old adage that justice delayed is justice denied could rarely be more applicable than in a case where, we have to decide who to vote for. And there's all these potential, not as though there's not enough evidence already with convictions, or particularly in civil suits, but the American people deserve to know, is there, in Richard Nixon's terms, is he a crook or is he not a crook?
Right.
And
I am not a crook.
Right. Yeah. This makes it almost impossible.
See, I feel like,
know, at least in a legal fashion, the degree of his criminality prior to the election.
See, I feel like if people were not swayed by his conviction this year, that this wouldn't matter. Like, I really don't think, even if he was fully convicted of everything he's been accused of here, that it would make much difference.
I think I agree. And Dr. Violin, taking your thoughts, I think this decision sets up a way for a president to act first and then apologize. Right? Don't prevent your action, just apologize, do it and then apologize for it later. Don't get permission, get forgiveness.
Although I don't know that you've had any Trump apologies. If we did, that would be one thing. We don't have an apology. I tried to stay in office even though I wasn't reelected. How do you apologize for it? And at the very least, when I got caught up in it, I thought, but we've had none of that. We've had a bearing down on that, saying that I've done nothing wrong. So
right. I think the decision to me isn't. I was hoping for a decision that would be more clear in terms of do not do this. Here's the line, do not do this, to help prevent presidential behavior that would cross a line versus allowing the behavior. It seems like it's a setup for go do whatever you want, then we'll review it, versus a preventative measure where it sets up a precedent, not necessarily Trump, but I mean, clearly we're talking about Trump, but it sets up a precedent for saying, well, based on this interpretation, I can do almost whatever I want, so I'll do it, and then you can review it, but it'll take so many years to go through the courts, it'll take so much time to have a hearing as to which of my every single individual actions, every phone call, every note, every discussion, every trip, every public speech, if we're so bogged down into the minutia that it seems hard-pressed for a decision, a president's decision to be reviewed in this case. So let's talk about, we'll get back to our continued opinions, but I want to break down the actual holding. So the question, as the Supreme Court put it, and make sure I've got this right, and I want to try for us to read from the decisions themselves as well. So what we've got is the question of whether, let me get back on this.
I have it in front of me.
Thank you. Please read it.
Yes. Okay. We grant, there we go. Sorry. Whether, and if so, to what extent does a former president enjoy presidential immunity from criminal prosecution for conduct alleged to involve official acts during his tenure in office?
Okay. And we got a fairly specific holding. It's somewhat general, but it's fairly specific. What was the actual holding based on that question that the court was reviewing?
Yes, let me scroll down in my highlights here in just a second. Y'all, I never make notes, and I have so many notes.
Well, I mean, it's basically absolute immunity, right?
Sort of.
I'm trying to find
it's some absolute immunity for quote official acts.
Right. Official acts.
But presumptive immunity for unofficial acts.
Or acts in the outer bounds.
Perimeter.
Yeah,
perimeter.
outer
There we
perimeter.
The periphery, I think, maybe.
I think they interchange the words.
They do.
So we conclude that under our constitutional structure of separated power, the nature of presidential power requires that a former president have some immunity for criminal prosecution for official acts during his tenure. At least with respect to the president's exercise of his core constitutional powers, this immunity must be absolute. As for his remaining official actions, he is also entitled to immunity. And then here's the caveat that they give, and we're going to break this down too. At the current stage of proceedings in this case, however, we need not and do not decide whether that immunity must be absolute or instead whether a presumptive immunity is sufficient. So they've set up a kind of a twofold test where they've decided, okay, absolutely for core constitutional powers, and we're going to break that down. But for these unofficial acts for the outer perimeter, outer periphery, then that's for a court to decide. And we're going to send that on back down to the trial court for them to hold a hearing and decide which of all of these, I mean, this indictment is really quite long. So the idea of breaking down which of the actions are official versus unofficial, I think is going to be fairly difficult for the lower courts. And my question to both of you, it seems that the trial court has to make the decision, but the way that it's set up to me seems like it is fact specific, right, as to what actions the president took. But is it really the judge, or did they set it up for a jury to decide as fact finder? That's my question to you all. Is it the jury's ultimate decisions as to which actions are official versus unofficial, or is it the judge? And in my mind, the way they've set it up, it's much more similar to a fact finder deciding. So let me give you an example. This is very close to me of a the immunity for police officers, right? Sovereign immunity. Okay. Most states in the federal government have sovereign immunity for acts done by police officers in their course of duty. This is extremely connective to me. So you can't prosecute them for some things. You can't find them civilly liable. Most of it is civil liability, right? If they do something in the course of duty, somebody dies, someone gets hurt, as long as they were acting within their parameters while they were on duty within the bounds, then they are not simply negligent. So they can't be found liable for simple negligence. But if you can prove that they were grossly negligent, many states allow civil complaints and liability for individual police officers. So even if they're acting in their own capacity as a police officer while on duty, if their actions rose to gross negligence, then they can still be found liable. But that is a jury decision. It is for the jury to determine, a plaintiff's attorney to say, these actions are not simple negligence. They go to gross negligence, willful, wanton conduct. And that is for a jury to decide. So
but they're
how
sending
is
it
this
back
different?
to a district judge, right?
Well, they sent it back to the district court.
Right. But there's not been a jury trial, right? And there's not one
Correct.
planned.
Well, I mean, technically one is planned in that this is a jury trial, but I think it's ambiguous, and I think it could be read either way as to the court is saying there hasn't, and Chelsea, I want you to address this. This is not a final review. This is an initial review, so hold that thought. So they've sent it back for the court to make all these decisions and then send it back up for final review. Chelsea, how does that set up?
Yes. So I read this and I was like, well, that's a way to kick the can down the road. They're saying, yeah, we're going to have to make this decision. Eventually it's going to get back up to us, but we don't want to look at it first, which I thought was insert eye roll here, right? I think that's absurd.
Can we bring up something so people listening, maybe they know, but this is a 6-3 decision.
Yes.
And unlike, if you go, the most comparable decision we have is U.S. versus Nixon.
And they reference that a
Well,
lot.
they do, which is an 8-0 decision and included, I believe Rehnquist recused himself, if I recall correctly. All three of the other justices that Nixon had appointed voted against him. Here's a case where 2.5 of the justices that he appointed voted for him, if you want to see it as a Trump or anti. And Barrett, I think I could live with Barrett's decision, which basically says,
which is a concurring opinion.
It's right. That's right. So it's still 6-3, but the reason I said 2.5 is, or 3, yeah,
3.5.
Is that what she argues is you ought to be able to use presidential communications, whether they're official or otherwise, to understand the background here. So you should, the president gets up in the State of the Union address and says, my vision for the next 4 years is to put Joe Biden in jail. They would say, well, that's an official act giving a State of the Union address, so you can't even consider it. That's ridiculous.
Yeah.
In my humble judgment.
I mean, I didn't realize the Supreme Court got to write our evidence rules too. That's news to me.
Interesting.
Yeah. I mean, to me, that it's even in qualified immunity cases, which I think is really not super comparable, but the closest thing we have. The rules of evidence apply. Police officers do not get special rules of evidence. Even though they're standard, like the federal standard for qualified immunities, it has to be like deliberately indifferent to the laws and the treatment. High standard, but they don't get different evidence rules. And I'm really confused why not only do we have this new immunity that has come out of nowhere, and now they also get different evidence rules. This seems absurd to me.
Well, the immunity doesn't completely come out of
okay. Nothing. Well, true.
So there's a case, the Fitzgerald case,
yes,
involving civil liability,
right?
and that's I think if basically where you get the official versus unofficial. Nixon had used his authority to fire somebody for what I think was an unjustifiable cause, but it was in the course of enforcing the laws as he saw them.
Right.
So,
they don't give us a clear, in this case, I feel like, and this is my frustration too. I understand the idea of we're making a legal decision and the trial court needs to sort of, hash out the facts. I get that. That seems normal Supreme Court decision to me. But what I'm frustrated about is that, sure, they're like, this one thing is very clearly an official act. The rest of it, good luck. We're not going to talk about it. And then they whined. I'm sorry, I'm mad about this decision. And then they whined about not having enough time to decide it and like, be so for real right now. I'm so mad about it.
Well, what's fascinating about it is there's a political theory behind this whole decision. And it's partly stated, but there's a whole school of thought in what's called the unitary president. And there's some constitutional basis for it. We have a single, and the court points out, this is the only, although given all the advisors and the cabinet and everything else, I don't know how, but basically they say the presidency is the only branch of government that only has one person. Congress, 538, Supreme Court, in addition to the 9, you got courts below it.
Right.
And
the lesser courts.
And they cite the Federalist Papers extensively, and I agree with that the president needs to be energetic. The president,
they were extremely focused on that.
Right.
Decisive, energetic.
What they have lost, in my judgment, and I think Sotomayor may be clutching her pearls a little too tightly here in some of the statements that she made, but you have to weigh. And the Supreme Court's supposed to weigh both sides. There's energy, but there's also accountability. And the one thing that the court got right for sure is they struck down the nonsensical theory which was contradictory by Trump's own attorneys, who, when he was being impeached, said if he's not convicted here, he can be tried later. And then they said impeachment gives us a pass. Mulligan. Here, the court correctly says that has no constitutional basis. It's completely made up. But having given with one hand, they seem to take from the other, which is, yes, the president is accountable, but you can't, absolute immunity for this, qualified immunity for this. You can't use, public, private, et cetera. And have we approached the point where the king is above the law, or the king or the president can do no wrong?
And that's what Justice Sotomayor is suggesting in her
That's
dissent.
right. I mean, that's and to his credit, I suppose, Roberts does say that the president is not above the law, but the question is not theory. The question is practically. Have you put the president in a position where he effectively or she effectively is above the law?
I agree with that. I think, like you were saying at the beginning, is Chief Justice Roberts' words are enticing. But when you parse it down and look at what's actually been decided, it appears contradictory to the decision, where Justice Sotomayor, she was writing for the dissent, the 3 liberal justices.
She was so
all women,
sassy.
by the way.
We
all
love
women,
it.
yes.
Oh no,
So,
is that? Yeah,
it
they
is.
are.
I think so.
Correct.
I almost choked when I opened the dissent and realized they quoted Dobbs in the first paragraph. That was so feisty of her. I was like, that was funny. I appreciate the little feistiness of quoting the Dobbs quote about like deeply rooted in American history. That was very funny. To also like quote the majority opinion on a case you also dissented on. Peak constitutional humor, I feel like.
Right. And I think it's worth reading out some of this dissent. And Dr. Weil, as you were pointing out the 6-3 decision, I think it was important that Chief Justice Roberts was the one who wrote the opinion. Right. I think that's extremely telling. But I do want to read some of these words.
And before you do we mention, Amy Coney Barrett, we mentioned the concurring opinion.
Correct.
What she says, which is sort of a middle course, is that she would not exclude investigation of what the president has officially said as evidence for the rest.
But it doesn't mean that it comes into trial, because based on Chief Justice Roberts' opinion, it appears that you can investigate him based on that opinion or what he's actually said.
Not admissible.
But it's not admissible into evidence as the facts and circumstances to give meaning to the actual actions that he's done. So in this way, to me, it's taken out, Chelsea, as you're saying, the need for proof of intent. That you can't even prove the crime because you can't prove intent. You can't use the actions or even the words, the defendant's own words, which normally would be an admission by a party opponent, and those words come in. But if you can't even use those words, how do you effectively prosecute anything and let a jury decide?
I also feel like, before you do this dissent, this is my little thought. I feel like I wish, instead of it being an immunity that like precludes prosecution, that this could be like an affirmative defense, right? That you could say, just like self-defense, like a prosecutor can bring the charges and you can say, almost like a public interest type of, why couldn't we make this a defense to a charge? Like an affirmative defense of like, yes, I commanded the military to do this, but I had to because I was president. I feel like that would make me feel better instead of just precluding prosecution altogether.
Well, I mean, think of the Cuban Missile Crisis. Right? I mean, just pause and let that sink in. That seems more apt in dealing with foreign parties, in dealing with treaties, threats to national security. In my mind, the decisions that were made by the executive branch, and specifically the president, as to what to do with that, what to do with the Iran-Contra affair, I mean, that seems well situated for immunity. But what about the domestic things that the president does?
The one thing that is really disturbing about this case goes back to the oral arguments, where if I recall correctly, and I don't know if it was Sotomayor or someone else, but someone said, so if you ordered the Navy SEAL team to take out a political opponent, and Trump's attorneys basically said, that he would have that power. And Sotomayor brings this back up.
She does.
Justice Roberts basically says she's hysterical. It's a good thing you didn't use that word.
Right. I mean, I'm a woman, so I'm hysterical.
Right,
yeah.
Right. But he doesn't specifically himself address that scenario.
Correct.
Other than, I guess, unless he thinks that it's consistent, that would be a private rather than a public act. But if he did it as commander in chief, I mean, surely even the majority would not accept that. I wish he'd just been a little bit more clear.
Yeah,
I think they don't think a president would do it. That's what I'm saying. I feel like this whole opinion is written as if a president would never.
So let's talk about, I do want to come, it's so hard. There are so many things going. No, you didn't.
Sorry,
because it's all part of it. So let me take up your statements about the oral arguments, because that is what comes out in the opinion of Justice Sotomayor, where she says, this is page 29, the President of the United States is the most powerful person in the country and possibly the world. When he uses his official powers in any way under the majority's reasoning, he will now be insulated from criminal prosecution. Orders the Navy SEAL Team 6 to assassinate a political rival, immune. Organizes a military coup to hold on to power, immune. Takes a bribe in exchange for a pardon, immune. Immune, immune, immune. Let the president violate the law. Let him exploit the trappings of his office for personal gain. Let him use his official power for evil ends. Because if he knew that he may one day face liability for breaking the law, he might not be as bold and fearless as we would like him to be. This is the majority's message today. And here's the part of that I think Chief Justice Roberts addresses is her end of, even if these nightmare scenarios never play out, and I pray they never do, the damage has been done. The relationship between the president and the people he serves has shifted irrevocably. In every use of official power, the president is now a king above the law.
And have we had any wilting flowers who have been president over the last 20 or 30 years?
The closest we've come is President Carter.
Yeah, perhaps. I mean, and again, but that's been a while, right? I mean,
that's more than 20 years.
If we've had problems, it's been over energetic presidents.
Mm-hmm. Yeah,
not under. I mean, problem we have is we have a completely dysfunctional Congress,
right?
Yep.
The other thing about this case is we got two of the justices whose views on the last election appear to side with Trump.
Right. I mean, we've got the flag. We've got Justice Alito. Right. Justice Alito is we've talked about this multiple times on our program.
I'm less concerned about him partly because that may or may not have been his view, but particularly about Thomas, we didn't mention his concurring opinion,
which is a bit rogue.
We do have a Category 5.
Yes.
Although he makes an interesting argument. I will give him that. He often does.
He does, but it's not based on anything related to this
that's
question.
Right. It's not based on any facts before the court, but his argument is he doesn't think the special counsel is legitimate, which we've had special counsels in dozens and dozens of cases.
Yes.
So who knows, how many cases this could disrupt.
And that's what the Florida judge is also questioning. She's having them brief both parties as to whether special counsel Jack Smith is even allowed constitutionally.
Right. But she's not arguing this case. This is a fact that literally was not before the court, as I understand it.
And they are only supposed to review the question before the court.
Right. He's just submitting his journal pages as his opinion. He's like, hey, guys, I had a thought about something. I would just like to submit this as a concurring opinion.
Yeah, so let's review as far as judicial acts. So the court says there's acts that are completely immune, absolute immunity, official acts.
Presidential.
Versus unofficial acts. And it says the lower court has to decide, but we're going to tell you. So in this, I think it's tongue in cheek of what Chief Justice Roberts is saying is we're not going to say what it is, but we're going to say what it is. So for the core constitutional acts that they say are absolute immunity, they include, now this is based on, Dr. Vial, I'm going to make sure that we have this right. Which article of the Constitution are we looking at for presidential powers?
Article 2.
So with Article 2.
1 is there's some about impeachment in Article 1, but primarily Article 2. Article 1 is legislative powers, Article 2 are presidential powers.
And then 3 is judicial.
Yeah.
So they're claiming, they're saying that the Constitution provides specific executive powers vested in the president, which is true. Absolutely true. And they get that right. And they actually cite those powers correctly. So they're saying that it includes commanding the armed forces of the United States. And Dr. Vial, I want to make sure that you can check these off as to, based on your understanding of the
Commander-in-Chief, that's actually the first power of the presidency is actually in office. The president is Commander-in-Chief of the armed forces.
Okay, so that's correct. Then they cite granting reprieves and pardons for offenses.
Exclusive power to the president. Yes.
Appointing public ministers and consuls.
Well, and actually there's a double side of that. They're using the Myers decision, which I agree with, that the power to appoint also includes the power to fire.
Mm-hmm. Okay. And so
executive accountability, responsibility.
Foreign relations responsibilities, they've listed as making treaties, appointing ambassadors, recognizing foreign governments. Are we good with all of those?
Yeah.
Yes. Now, we're good with them, but let's go to the first one. Your president, your commander-in-chief of the armed forces, to go to what you made earlier, does that give you the right to invade Arkansas?
Right.
Or maybe Delaware, since that's where the president, the current president is.
And
Go ahead and move the capital of Florida while we're at it.
Yeah, okay.
Exactly. So it's foreign leaders overseeing international diplomacy, intelligence gathering, managing matters related to terrorism, trade, and immigration. And they're very specific as to conclusive and preclusive authority for anything regarding those powers. So they are the core powers listed.
Well, one other, right? The chief domestic power of the president is the power to execute the law.
Correct.
And they're using that power to say that any communication you have with your attorney general or anybody in the Justice Department, and this is where I think it gets very dicey, because yes, the president has the power to enforce the law, but this is subject to judicial review, and it's subject to due process.
Right.
And the notion that a president, could call his attorney general in and say, the first thing I want to do in my new administration is to put Biden behind bars, and I don't care how you do it. That's what we're going to do.
Yes.
I think that would be a conversation that we would need to know about. I don't care who it's with. I don't care if it's with the Pope.
I agree.
Yeah.
And that's exactly what they're saying, is if it's within this sphere of core work, working with the attorney general, working with the Justice Department, they specifically mention, like you're saying, that if it's an investigative proceeding, they have command over all investigations. So it gives whoever's in power, presumptively if Trump were in power, him the ability to follow through on the threats if he's going to retaliate against his political rivals. So he can use the Justice Department as the long arm, of whatever his motives. It's his official power as president. Now, I will say this. As much as Trump feels like this is a win for him, that he can use the Justice Department to go after his political rivals, I don't think he can now complain that Biden, his Justice Department, has gone after him. So what's good for the goose is good for the gander. I don't think his Justice
Department has. I don't think Biden.
I don't think he's responsible either. But let's assume, or hypothetically or theoretically say that he has used it.
No decision by the Supreme Court is going to lead to consistency on the part of Donald Trump.
That's
probably any other president. Okay,
right. But
I like your
your
thought that the world is logical, but you may remember that you had a father who told you that life isn't fair, and
yes,
I should have added that it's not also often not very logical.
No, I agree, but logically speaking, isn't it true that if the court is saying the president, so let's put Trump, let's put Biden's name in there, the president is allowed to use the justice system to investigate whomever he wants, then doesn't that reasonably, logically conclude and lead to the conclusion that Biden can do what he's been doing, if you believe that it's Biden?
Sure.
Yeah, okay, wait. Maybe I'm not tracking what you're saying, because I feel like Trump can just say, yeah, that's why I'm a felon now, because Biden's coming after me. That's what he's going to say, right? He's like, see? The Supreme Court said that's what a president can do, and that's what Biden is doing.
Right.
I think that's what it turns into, which is illogical and silly and untrue. But I think he's a master of spin, right? Like, you can just take anything and talk long enough that it means something else.
Yeah, and I think this sets up, and this is why I'm not dismissing Sotomayor's decision or her dissenting opinion. And yes, it's dramatic language. I believe she felt that it needed to be. That she believes very strongly this is a dire situation with potentially dire consequences. And in my mind, we were speaking beforehand, and I want to bring this up on the official podcast, is Dr. Viles said, well, the one thing this makes clear is that, Trump's saying that he can go and shoot somebody on the street. You can't do that. And I don't think it is so clear as that. I think this decision, based on all of the core constitutional powers that are mentioned with absolute immunity, okay, maybe he can't do so personally, but what's to prevent him from exercising his commander-in-chief power and sending military personnel out to shoot somebody on his behalf? And then we can't even question his motives.
Well, we've said the president is commander-in-chief. Congress has the power to declare war.
But
Congress
domestic
has
war
the
wouldn't.
power to appropriate or not appropriate for war. So it may not be quite as clear cut in terms of, yes, there's only one commander in chief, but I don't know. I mean, I would have felt much better if instead of just saying, Roberts basically saying that Sotomayor is hysterical, is saying, of course, this doesn't mean this, and here's why.
Right.
If he had done that, I would feel a lot better instead of just saying, you're going too far. How is she going too far? What assurances do we have that the hypotheticals that she raised are not real possibilities? Now, I honestly don't think we've ever had a president who would do any of those.
Right.
And I hope we never would. But again, we've increased presidential energy without increasing presidential accountability.
Oversight. Right.
And one of the things about the Constitution, we forget this, it grants powers.
Right.
But it also limits powers.
Correct.
And I think, my main criticism here is that the court went too far in one direction, went too far in the energetic president and not enough to the accountable president. And that's the part of Sotomayor's decision that I absolutely agree with.
Yeah.
Yeah, I had in speaking with my father-in-law about this, he I'm not sure where he got it, so I wish I could quote a source, but I can't. But the essence of his statement, and I think it was a legal pundit who was speaking. Goodness, I wish I could remember. I'll try to. But the essence of the news article about this person's take on the decision was, oh, okay, well, we the justices don't have any oversight of ourselves. Right.
Yeah.
That we're not accountable to anybody. We can commit all of these ethics violations and nobody can remove us. So we'll give the president the same power. So now the two of us, but 2 branches out of 3 are now immune, have no oversight, have no accountability. We can continue to remain in office doing whatever we want. So as preposterous as that somewhat sounds, it also is fairly logical. Where is the oversight of all of them? And they specifically say in Chief Justice Roberts' opinion that there is now I'm going to lose the specific part, but it's absolute immunity without review. They're very clear on that.
Yeah,
without review of his powers.
Absolute anything. And the I think it's Sotomayor who quotes Lord Acton, right?
Mm-hmm. Yes.
Power corrupts. Absolute power corrupts. Absolutely. That is a long-standing principle that doesn't get enough attention here in the majority decision.
Right. And here it is on page 7. In keeping with that, Chief Justice Roberts states, when the president exercises such authority, which is these core constitutional powers, he may act even when the measures he takes are incompatible with the express or implied will of Congress. The exclusive constitutional authority of the president disables the Congress from acting upon the subject. And the courts have no power to control the president's discretion when he acts pursuant to the powers invested exclusively in him by the Constitution. So that's exactly what they do, is they say the president has all of these powers with no oversight. We cannot and will not review his actions, review his motives in applying his use as commander-in-chief with respect to foreign affairs, with respect to pardons. So I agree. I think that's exactly where this is headed, and it would have been better for him to say, of course we don't mean that. Of course we don't mean that. But instead it's, well, we do mean this. And then they say specifically, they're saying, oh, well, the lower courts can decide. And this is what frustrates me. The lower courts can decide what's official or unofficial, but here's what's official.
You know, there's an interesting parallel in the pardon case. You know, we have an ongoing case right now in New Jersey, Mr. Menendez, as to essentially whether he's taken bribes or not.
Right.
And what evidence you can use. And as much as I think the president does have near complete power over pardons, I think that if somebody, I mean, could someone say, I'm going to give you $1 million if you'll give me a pardon? I'm going to personally give, not just to your campaign, I'm going to give you personally $1 million. I'll give you the money to build your Trump Tower down there in Saudi Arabia or wherever you want the next one. For a pardon, and you would say that would be acceptable behavior. And I believe it's Sotomayor
Can't question the motive.
Okay, well, Sotomayor points out that there are some cases where the Constitution specifically granted immunity, and one of them is, and it comes out of the Menendez case, is that you can't question a member of Congress for something that they said on the floor of Congress. And that is something of a limitation, because it means trying to prove bribery. You can't, if Menendez gets up and says the Egyptians are the greatest people in the world, you can't say, well, he said that just the same day he got a $500,000, gold bar or whatever it is. Right. And the fact I think she makes a pretty good argument that when there's that absolute immunity, the Constitution specifies what the immunity is. And this is, there is not, as I understand it, the Constitution doesn't give immunity. Doesn't mean it shouldn't exist to some degree. But anytime you get to something and you start calling it absolute, go back to Lord Acton and think about it a little bit.
And let me throw something out there with that is, to me, this effectively undermines the impeachment authority of Congress. Because
Absolutely.
You can be impeached, according to the Constitution, for high crimes and misdemeanors.
Right. How are you going to find out
whether you can't be prosecuted for the crime of it all?
You can't be prosecuted for the crime. So if the president is immune from this criminal action, then why would it be a crime for the president? Right. So how would you impeach or remove a president for high crimes and misdemeanors?
Right. The sad thing is how long the court sat on this.
Yes.
To come up with this decision. They would have done far better never to have taken it, let it percolate up.
Yeah.
And then if you had some kind of miscarriage of justice, then you come back.
Yeah.
But, this is, if you go to balance of power, the court has clearly grabbed power for itself in this and other cases, or if not grabbed power, it's reasserted its final authority to say what the law is, and they've increased the power of the president. What's the weakest branch of government right now?
Congress.
It's probably the branch that the founders thought was going to be the most powerful.
Which is Article 1. The first thing they established was the legislature.
Exactly.
As and they thought, equal power.
Yes.
Which is the most ineffective at this point.
I think this is interesting in the decision too, and I want to hear sort of y'all's thoughts on this and I was talking to my mom about this, of course. Everyone knows I get on the podcast and I force my mom to listen to my legal analysis.
As she should.
And she's like, right, as she should.
Super fan.
She shouldn't need forcing, right?
She's like, Chelsea, I did not go to law school. And I'm like, okay, well, let me explain this concept and tell me how you think about this. I swear that's our conversation every day. Anyways, so it's this weird thing, right? Because they say absolute immunity from presidential acts, for sure. And then they said not not immunity from things that are clearly personal acts. And then we have this weird, like, overlapping Venn diagram middle space that they say there's a presumption of immunity. And you were a prosecutor, Virginia. How would you overcome a presumption of immunity? Like, what does that look like in practice? Because I can't wrap my head around. This is so fun. Let me be clear. So fun, Supreme Court. I love thinking about this hypothetically. I cannot wrap my brain around this in practice.
It's a very hard burden. It's an extra burden of proof by the prosecution. It is burden shifting. So you start with the presumption that all of the president's actions are immune.
Yeah.
All of them. So it's now the prosecution's burden not to prove the crime, but to prove that when the president acted with every single specific piece of his actions over how many months, how many years, that you have to go step by step and prove that. And it's weird because they didn't say beyond a reasonable doubt. They didn't say clear and convincing.
Question.
You already have that standard, and now you've added.
Yes.
It's like, what's the standard higher than reasonable doubt? It's beyond reasonable doubt plus presumption against using evidence.
Right.
Right. So that was my question. In the practical application is the presumption. So I'm assuming reasonable doubt standard of, having to overcome this presumption, but you also can't admit into evidence any of the official, am I tracking that correctly?
You are tracking it. And it's weird because with rebuttable presumptions, it depends on which laws and which states you're using, because some rebuttable presumptions, it has to be a response with clear and convincing evidence.
Yes.
Some it's beyond a reasonable doubt. The court does not specify which burden it is. It just says it's presumptively, absolute immunity. You have to prove that it's not without the guidance of the level of proof. So at this point, I think it has to be presumed that the prosecution has to prove beyond a reasonable doubt that these are
that's what I assumed.
unofficial
it's a criminal, right? Yeah,
and that they were criminal, specifically violative of the law.
But also, to do that, you can't use anything that is official presidential duty. So as you were saying earlier, Dr. Viles, so if someone comes out in a State of the Union and is like, I'm going to wage a war on the other political party, you would not be able to admit that into evidence to prove that they don't have immunity, right?
Because he's addressing the United States. He's addressing the public.
This is a nightmare hypothetical scenario, by the way. I feel truly, going back to what I said at the top, con law students and teachers at the moment, I do not envy you, because this feels like a nightmare. Like, I feel like I'm in a nightmare hypothetical right now. This was every law school stress dream I had of the most insane constitutional law question on an exam. I'm like, it's so hard for me. And I read it, I took notes, I probably talked about it, forced my mother again to talk about it for 8 hours yesterday. And I'm still what does this look like in actuality? Let
me throw out another nightmare situation.
Oh, God.
And I challenge anyone who's going to call me a hysterical woman. But if they're going to call Sotomayor the same thing, then of course they can call me the same thing.
You're in good company then.
But what about us?
Yeah.
And think about that and let that sink in. If Trump were reelected,
right.
We've done a podcast where we try to be neutral and fair, but
every episode I'm like, I hate everybody.
Right, but clearly our opinions do come out. And what's to prevent us, if Trump is elected? We're small potatoes out there, right? We're not on Fox, we're not on CNN, we're not, in national news, but we are national. Not yet. That's right.
There we go.
We'd love to be, we're happy to be. But have we set ourselves up for expressing opinions against Trump in certain ways? Not always, but in some times. Right. Have we set ourselves up for being political rivals who would be subject to investigation and prosecution? And how far down this rabbit hole do we get for exercising now our First Amendment rights of freedom of speech and freedom of press. So how far down does this go, and how many different countries, not that we're, Germany, et cetera, but how many countries for exclusions of China, of Russia, of Nazi Germany, where it's political prisoners too? And how much have we, as Americans with democracy, railed against that? We shouldn't be lumping political prisoners in. It's just for expressing different opinions. So that's if we're talking nightmare scenarios for the general public, I do fear, not so much, political figures, right? Congressmen and women. Yeah. Of course, that makes sense. You've chosen a side, et cetera. But if you've chosen as we people or the constitutional law classes and professors, that's my concern of where this goes.
I also just would love someone to explain to me, because, I'll admit my ignorance here. What is the difference between a president who we have authorized for, decades at this point, to have executive orders, who has the power to do that, and absolute immunity? If someone can explain to me how that is different than a king, I would love to hear it. Because how is that any different practically? Like, if you just have the power to have these executive orders and you're immune from accountability from that, how is that not a king? I don't know what I'm missing.
I agree.
Well, executive orders can be ruled unconstitutional.
Okay.
But
I don't think it's going to happen by this court.
Depends on which executive orders you're talking about. Biden's latest in dealing, for example, with student loans has already been stopped by the courts, or part of it has been. So there are some checks there.
Okay.
Dr.
That makes me feel better. Okay, that makes me feel a little bit better.
Let me go to you. You are an expert in the founding of our country, the original Constitutional Convention, the founders of our Constitution. In looking at them with everything including Jimmy Madison, Thomas Jefferson, all of these wonderful characters that we have, what do you believe was their intent for the president versus what they were leaving with England?
Well, this is, again, Roberts is not completely wrong. They wanted, you were reacting against two things. You're reacting against George III. You're actually reacting primarily against parliamentary sovereignty. And they were expecting George III to intervene on their behalf, and he did not. But the theory of the day was that the king is above the law, and they didn't want that. But they were also reacting to the Articles of Confederation, where you had no independent executive, and they were reacting to state governors who typically had one-year terms and very limited authority. And so they were trying to thread the needle between, we don't want a king who's arbitrary, but we do want someone who's going to be able to act with dispatch on behalf of American interest. And I don't think, I think they would be shocked by this decision. I think absolute immunity, that word absolute just sticks in my craw. It's not in the Constitution. The only place the closest we come is in the part of the Constitution that says, that Congress or the Senate the House shall have the sole power of impeachment, and they focus on that word. Sole means they make the decision and nobody else does. Right. But the Constitution is very wary about giving complete, authority. And yes, there's one president. But again, the reason we have one president, it's not just for energy, it's for accountability. Right. If there were three presidents, two would always be pointing their finger, or one would be pointing the finger at the other two. Right. And I think the balance is off here. That yes, we need a vigorous executive. Think about it. We've had 40. We're on 46 now, right? Presidents. Yeah. This is the first time, I guess the way paranoids look at it is, we started to trend here. Now we're going to start prosecuting every president. But I don't think most presidents are going to be prosecutable. I think they would be laughed, George Bush, I disagreed with a lot of his decisions, but I thought the idea of, an international court's going to arrest him for a decision he made as to whether to invade Iraq or not, I just think that's ridiculous. Somebody had to make that decision, and it might have been wrong, but he had, with Congress, had the power to do it. But
if a president does something a grand jury is willing to indict on, then good, prosecute them.
Well, that's right. There are all kinds, and the lower courts pointed this out. There are all kinds of protection.
Yes.
And, if you want to add a little bit and say, particularly when it comes to the president, one should be very wary. I get that, but I just think it's out of kilter. I'm very disappointed. I'm saddened by it, to tell you the truth. And I'm particularly, I give Amy Coney Barrett a gold star for at least, trying to modify the majority. But, it looks bad when all three appointees vote for him. And basically, it's basically, apart from Barrett, it's completely ideologically split. And that suggests to me that none of them maybe or not enough of them are, trying to come up with something that's going to be good for both Republican and Democrats, Trump, Biden, anybody else who fill the office. We're close to an elective king here.
Yeah. I think it's shattered the illusion. And again, I go back to just the con law teachers. I feel bad for them. This has shattered the illusion of, or what was left of it. I think I was probably pretty jaded coming in, that the Supreme Court is not a political machine. I think it's always been that. And I think they are just really solidifying that
it's always been that, but in high points in history, particularly, one of the reasons I love the court so much, I can't help it. U.S. versus Nixon. Yeah. I felt they stepped into the breach, but for their action, the tapes would have never come out. Nixon would not have resigned. We would have, we would be in greater trouble than we are now. Yeah. And there have been other times in steel seizure case.
Yes, which is mentioned.
I don't think Truman was doing this for a personal reason or anything, but the court stood up and said, no, just because you're commander in chief, you don't have the power to seize private industries. That's very different from we're going to give absolute immunity here for any president. How would you decide that case in light of this decision? Core presidential power. Now, again, that's where they're not quite right on the commander in chief, because it's Congress that has power to declare war.
But that doesn't mean domestically.
Well,
and I think that's where we've got this issue.
Again, in the steel seizure case, I think they probably got it right. And they do, by the way, they do cite that case. They cite Jackson's concurring opinion, which is the one that everybody always cites, which is the president's powers are greatest when he acts with Congress, less when it's against. But the truth is, that's not a very good formulation. President's powers are greater when the Constitution specifically gives him a power.
Right. Well, I'm going to throw something a little bit wild out there.
Yes.
And
category 4 to 5. I think.
Yes, I'm going to give a category 5 of my own.
The more we've talked, I think we might have talked ourselves into a category 5.
I think so.
Well, I'm going to throw something. If it's already a category 5, I'm going to throw something out there. Biden still has how many months left as president? He is still currently president.
4 years plus. We don't know yet.
But at the very least, he is still president, at least through the end of this year.
He has the opportunity to do the funniest thing ever.
6 months.
He can take this decision, and just as Trump wants to wave the flag and say it's a decision for him, Biden can say, absolute immunity, you say?
Let's go.
Let me act on my absolute immunity that I still hold, and let me do X, Y, Z. Let me test the parameters. Why should it be reserved for whoever the next president is? If they say it now, I'm president now.
Yep.
One thing that the court leaves ambiguous that I think we need to touch is we do not know, or I cannot tell after I read this, whether the information about Trump's interactions with Mike Pence are
yes.
or are not official acts.
That was not
The court
decided.
suggests that his role was merely ceremonial, which would mean that this maybe isn't an official
Right.
act, but it doesn't say for sure. And that, in some ways, is one of the greatest potential crimes, if you will, or abuses of power that we had in the presidency, is trying to convince somebody not to read out the numbers as he sees them, but as Trump wants them to be.
Yeah, I agree. And at this point, I think it would allow Biden to say, you know what? I did go and get your papers out of Mar-a-Lago. I did authorize this. Maybe he didn't, but to say I did authorize this, I did authorize that, I'm
So
immune.
you thought it was a witch hunt before? Watch these next 6 months.
The court said I could do it, so I've done it. My justice.
We don't go there.
And I don't want us to.
No. But it would be funny.
This is the absurd and the ridiculousness of where I see this decision.
Yeah.
Is, with as many, as far reaching as these parameters are, this is what I see is if we're looking at it as the court wants us to do, the court doesn't want us to look just at Trump. The court wants us to look at the presidency.
Right.
So as ridiculous and as absurd as I'm sounding, this is what's open to the presidency.
Right. If we elect
whosever
Napoleon,
name it is. Correct.
what have we got? That's right.
Correct. So not that I'm encouraging any of this behavior. I don't think it's appropriate for anyone, be it Biden, be it Trump. I don't think it's appropriate for Biden to be using the justice system to go after Trump. I don't think it would be appropriate for Trump to use the justice system to go after Biden. I'm not sanctioning any of these actions, but I go back to what's good for the goose is good for the gander. And if there's absolute immunity and motives don't matter, then that's what it's set up for. Put somebody else's name in. John Smith, Jack Jones, who cares? Let's put a name in there. And if he's the president, then he can do it. Or she. That's how I feel about that.
I love it.
Yeah, that's my outer limits of this absolute immunity.
We should really make sure we test the limits of it. It's a new decision. Let's just stretch our arms and see how far the court is really willing to take this. I think that's a solid plan.
Right. Ask forgiveness rather than permission. The court seems to have given me permission. Let it
Never ask
later say
motive.
I shouldn't have. Right. So, okay. Well, I think I've effectively driven that into the ground. We're going to stop there. Again, we're happy to take comments. We're happy to converse, but please, no name calling, right? No name calling.
If you do, tag me.
No.
And by the way, if you call me a name, I'm never going to read it, so don't worry.
Yeah, Dr. Vile won't care.
I will defend your honor, Dr. Vile. I'm ready in the comments.
It's wasted on me because I don't do social media.
Well, we do all still have the First Amendment freedoms, right? And we absolutely respect and appreciate those who don't agree with us. We've tried to analyze it in terms of what was said, what wasn't said, what we believe based on our expertise and background, what we believe the implications are. But certainly we're not trying to prohibit anybody else from sharing theirs. So like and subscribe so you can see our next ones. We are going to take up the final court decisions in our next podcast. Make sure to subscribe so you can catch all of them. We've got a number of our podcasts coming out this week so that we can cover all of the significant decisions that have come out the last week of June, the first week of July of 2024. So catch us there. Don't forget to share our podcast. If you like what you're hearing, you like our thoughts, you like our opinions, our analysis, please get it out to your friends so that you can share us. And don't forget to go to thelawunscripted.com for preparation for bar. Bar materials are on there for law students who are studying for the bar, as well as for law students going through the 8 core subjects, including torts, civil procedure, criminal law, etc. So take a look at those as well as some other free materials and resources. We also have course outlines, and apparently as of yesterday, we have a little bit of merch. So take a look at that, see if you want anything, and we will catch you next time on the Legal Weekly Wine.